read from a piece of paper, as opposed to a more extemporaneous um, lecture. Okay. All right. As the title suggests, remember I told some of you that there were so many things going on, and I couldn't pick a topic to talk about, so I decided to talk about all of them, kind of all of them. Let's begin. Are we on? Let's begin with current events and three news press conferences in particular. In the first one, the Chief Justice, Maria Lourdes Sereno, in what is now an annual event called Meet the Chief Justice, a very 70s title for for a show, um, spent some time expressing her views on the President's thoughts on the Supreme Court's decision on Araulio. And apparently, there were questions about the tension between the chief executive, and the chief justice, and her thoughts on the matter um, are on the board right now. She said, repercussions and reactions of our decisions are already beyond the control of the judiciary, meaning it should not shirk from its constitutional duty, even if it may result in inconvenience. It is not her duty, she added, to mend ties with the president for any inconvenience their decisions might have generated. Obviously, in response to some criticism about the way she's messing things up between the two branches of government. Then, a few months later, is it a few months later? And the Foreign Correspondents Association of the Philippines, um, the same questions were asked of her. And in this one, she said, we will, she said that the court could not have refused to hear Araulio or decided on the case of Araulio because we will have a court that is criticized for not stepping up and defending the rights of the people in accordance with existing constitution. That's what she said. And once again, she explained that the court cannot refuse to hear a case because it can lead to more complications for other branches. I think this is not the way a court should function. So she's still addressing questions. You know how the press here, when they ask a question, is more to sow intrigue, right? And that's her response. Now, when it was the president's turn to speak to the FOCAP, what he demonstrated was he was a really bad student. Bad student because the chief justice has been explaining things to him about how the system works, and still, despite every lecture that he's been to, I'm sure he's heard them, he remained adamant. And then his plan, his response to Araulio, is to amend the constitution. But look at the other steps the other things that he's saying here. There has to be a balance between the powers of the executive and the judiciary. Apparently, there is none, or there is no balance at the present, or else why would we need to amend the Constitution? And then he cites that case and other Supreme Court decisions, and to drive the point home, the court should not have invoked jurisdiction. So the president has very specific criticisms about how or when the court should assume jurisdiction over a case. And in his view, Araulio is one of those cases where the Supreme Court should have interfered. Okay, that's our introduction. The Arroyo Court. The president, as you may know, because most of you are my students. Yes, most of you are. Because I was informed that we might have visitors, so I dressed up. No, that's not it. I dressed up because all the other professors dress up when it's their turn, and I thought, I want to look good. Okay. The president, as you know, is not a stranger to what? Fighting with the Supreme Court. And his battle with the Supreme Court began with what I call the Arroyo Court. And the reason why we call it that, and the reason why the president fought the Arroyo court, is because this court really couldn't, I think, uh, convince the public or dispel the notion that they were not biased in favor of Gloria Macapagal Arroyo. And some of the cases that gave you nightmares come to mind. Like what? Like Udani, where the Supreme Court created a military exception to congressional investigations without considering the nature of the information that was required of the military officers. The Supreme Court said because she is commander in chief, she can prevent these people from testifying before Congress. Neri versus Senate, what is that? Committee on Accountability of Public Officers. Here, the Supreme Court micromanaged the Senate, and it became a clearinghouse for questions that the Senate may ask, and that is really what really bothers me about that case, is that apparently the Supreme Court can check what questions the Senate may ask when it is conducting an inquiry or a congressional investigation. Certainly not in the spirit of Arnold, the Arnold cases that came decades before this one. What else? Biraogo. The, the corrupt, apparently, can also seek refuge with in the Supreme Court because you can now invoke the Equal Protection Clause to strike down any attempt to investigate corruption during your administration. Okay? I know this is disturbing news for people, for justice-loving people like you. And then we go to the Castro versus JBC. And that's from our last class. We know that the Supreme Court reversed in Valenzuela in order to justify the appointment of Renato Corona as Chief Justice despite the ban on midnight appointments in 2010. What else? So, altogether, that's just a sample, and you know that. Altogether, Arroyo, her administration was, I think, immune to investigations because of the series of Supreme Court decisions. The military doesn't have to appear before the Senate. Questions have to be clear before the Senate. And then, when the Aquino administration tries to investigate the Arroyo administration by creating a Truth Commission, Supreme Court sides with Arroyo again and says, oh, you can't do that. You have to investigate everyone since time immemorial. Okay. Biraogo, I wish somebody would tell me if that's the correct way to pronounce that name. I have no idea. Became the last straw for the president. And during this summit, which I keep mentioning in class, the first Criminal Justice Summit in Manila, President Aquino delivers a speech, then starts to criticize the Supreme Court for his bias. And among other things, he cites De Castro, he cites Biraogo, and he starts wondering aloud whether the Supreme Court is on the side of justice or not. Then he ends his speech and shakes the hand of the Chief Justice. I love this picture because I can't imagine what they're all thinking. I think Enrile is having the most fun. Diba? I mean, look at all their faces. I think the president was saying, take that. and I think Enrile might have heard it. There's no way not to put this picture up there. Okay. But even as the president took the steps to impeach the Chief Justice, the Supreme Court, and I discussed this elsewhere, so I will not dwell on it here, kept on deciding cases in favor of the Chief Justice while the Senate trial was going on. While the Senate trial was going on, in effect, creating a defense for the Chief Justice. And in one of these cases actually says, one of the grounds for the impeachment, the Supreme Court actually says, well, the Chief Justice didn't do anything wrong. So if you were the president, and all of this was happening, you're probably going to be all the more convinced that this court has a bias against the Arroyo administration. in case you don't know, these are the cases about what evidence is admissible against the Chief Justice in the Senate trial. So in all three cases, Supreme Court said, no, you can't do that. No, you can't do that. No, the Chief Justice is innocent. We'll get to that part. Now, even I thought that the impeachment of Arroyo, rather, I wish, the, the impeachment of the Chief Justice was packaged as a crusade against corruption. That was, I think, the official narrative. And it was easy to believe because I was familiar with the cases that I just presented before you. And because of the things that I knew about the Chief Justice. And now, everything seems to have settled down a bit until the Supreme Court decided against the President in the case of Araujo. And then things really, really changed. Where's my picture? Oh, there. I love that photograph. There's no reason to put it up there. It's just great. Because that is the Senate Sergeant at Arms blocking the Chief Justice from leaving the Senate building when the Senate President said, no one is leaving this building. That's like a great photograph of what we mean by separation of powers. Right? Even he has to apologize and say, I'm sorry, you are not allowed to leave, because that's what the Senate President said. Now, today, there's another siege on the courts. You know that the President, before the SONA, went on national television and then attacked the Supreme Court for its decision in Araujo. In that address, he said two things that the media obviously reported back to us. One is the threat, it's embodied in the threat of a third branch of government intervening in the dispute between the judiciary and the executive branch, which could be interpreted only in two ways, or at least was interpreted in two ways. One is the threat of impeachment, and the other one is legislation to hurt the third branch of government for daring to interfere with the executive branch. And of course, the President didn't stop there. Even today, he keeps on talking about how he needs to stop the Supreme Court from exercising judicial review. And one of the first things that happened the following day is that a bill is filed in Congress to abolish the Judiciary Development Fund. They say it's not because of what the President said the night before. It's just coincidence that the following day they were about to abolish the Judiciary Development Fund. Now, there it is. There's actually a bill now. The administration, everybody who hates the Judiciary Development Fund, tries to paint it as a form of pork barrel. It's not, because there's no discretion. First of all, it's not an allocation of Congress. We generate it from the operations of the courts. And there's very little discretion involved in the use of the funds. The presidential decree tells us exactly how the funds are going to be used. So they cannot debate. But at this point, I'm trying to illustrate that there is a siege. Okay. There, I just said that. Sometimes you don't want to practice because you ruin the sequence of the slides. That's exactly what I just said. Next. They're trying to summon the Chief Justice. And when she said, I don't think that's appropriate right now because of the cases that are pending with the Supreme Court. So they said, well, maybe we should impeach you. I'm not making this up, okay? This is like in the news. You don't want to show up? We're going to impeach you. This one is on Justice Ardeleza. I do not have any objection with Justice Ardeleza, not because you're here, ma'am. I am a fan, and I'm glad he's in the Supreme Court. But, as I told you, I still don't understand why the Supreme Court gave the President enough time to appoint Justice Ardeleza when it could have. If it was really a problem between the two branches, they could have delayed it one more day and then the president would have been bound to appoint someone from the short list. So this is not about whether he should be there or not. It's about how much control does the president have with the Supreme Court, that they would oblige him and say, oh, we have to make a ruling today, or else the deadline will come, and then you would have to appoint somebody from the short list. Right. Now, the motion for reconsideration by the JBC makes this interesting, but I don't see them reversing it just because think of the consequences if they reversed it. Next, I said that already. The law. Another favorite photograph that I find. This is, in one picture, how the system works. And it applied to the U.S. Supreme Court when the U.S. Supreme Court ruled that the EPA, if I'm not mistaken, had to concern itself with carbon emissions. And you know that the Republicans and big business, they don't like over-regulation, so they were trying to argue against that. But the Supreme Court made a ruling, and George W. Bush, no matter what you thought about him, does exactly what every president should do, which is grumble, but do what the Supreme Court says. That's your job as the president. Grumble, say perhaps you disagree, but then say because you are the president, you have no choice but to follow what the Supreme Court has said. That's what Al Gore said when the Supreme Court said George W. Bush won the election. I disagree, but because the court has made a ruling, I will follow. Now, we know this part. We know this part. Well, you better know this part. We know that, well, here's the source of my aggravation is that everything the president seems to be doing violates everything we talk about in the classroom, right? And we know, and this is from Marcos versus Manglapus. This is from Marcos versus, wow. Oh, it's not. Hold on, please. Then from Marcos versus Manglapus, what do we find out? That the Supreme Court said, the 1987 Constitution explicitly provides that the legislative power shall be vested in the Congress, executive power shall be vested in the President, and the judicial power shall be vested in one Supreme Court, and in such lower courts as may be established by law. And these provisions not only establish a separation of powers by actual division, which is from Angara versus Electoral Commission, but also confer plenary, legislative, executive, and judicial powers subject only to limitations provided in the Constitution. And the grant of judicial power means a grant of all judicial power which may be exercised under the government. And only the Supreme Court can do that. From Abueva versus Wood, the separation of power means that each branch of the government should be sovereign and supreme in the performance of its duties within its own sphere, and it should be left without interference in the full and free exercise of all such powers, rights, and duties which rightfully belong to it. Each department should be left to interpret and apply within the constitutional powers conferred upon it without interference what may be termed its political duties. For one department to assume to interpret or to apply or to attempt to indicate how such political duties should be performed would be an unwarranted, gross, and palpable violation of the duties which were intended by the creation of the separate and distinct departments of the government. All the cases in this part of the lecture tell us that one exact thing. When we separate the functions of government, the other one is not allowed to tell the other one what to do. And that's why I'm aggravated. Because the president is telling the Supreme Court what to do. And the president has determined how to interpret the Constitution, and his interpretation differs significantly from that of the Supreme Court. He cannot stand it. And to settle the issue, his remedy is to amend the Constitution. Right? More from the Supreme Court. We have already said that the legislature, under our own form of government, is assigned the task and the power to make and enact laws, but not to interpret them. This is more true with regard to the interpretation of the basic law, the Constitution, which is not within the sphere of the legislative department, etc. Under such a system, a final court determination of a case based on a judicial interpretation of the law or of the Constitution may be undermined or even annulled by a subsequent and different interpretation of the law or of the Constitution by the legislative department. That would be neither wise nor desirable, besides being clearly violative of the fundamental principles of our constitutional system of government, particularly those governing the separation of powers. The case law is so solid, it is unshakable, which makes you wonder what the president has been studying or what his advisors have been studying. The doctrine of separation of powers calls for each branch of government to be left alone to discharge its duties as it sees fit. Being one such branch, the judiciary, as Justice Laurel asserted, will neither direct nor restrain executive or legislative action. The legislative and executive branches are not allowed to seek its advice on what to do or not to do. Thus, judicial inquiry has to be postponed in the meantime. Before a court may enter a picture, a prerequisite is that something has to be accomplished or performed. This is what we mean by the requisites for judicial review. The court is entrusted exclusively with the judicial power to adjudicate with finality, all justiciable disputes, public and private. No other department or agency may pass upon its judgments or declare them unjust upon controlling and irresistible reasons of public policy and of sound practice. That is from In Re Laureta, just in case you didn't read it when it was assigned. And I can't help it. I'm sorry. Okay na sana eh. And another one, the sound, salutary, and self-evident principle prevailing in this, as in most jurisdictions, is that judgments of the highest tribunal of the land may not be reviewed by any other agency, branch, department, or official of government. Once the Supreme Court has spoken, there the matter must rest. Its decision should not and cannot be appealed to or reviewed by any other entity, much less reversed or modified, on the ground that it is tainted by error in its findings of fact or conclusions of law, flawed in its logic or language, or otherwise erroneous in some other respect. This on the indisputable and unshakable foundation of public policy and constitutional and traditional principles. In Re Borromeo. Everything the president does lately violates everything I just read. Isn't it annoying? He's just violating everything he said. You cannot tell the Supreme Court it's wrong. You cannot interpret the Constitution. You cannot reverse a decision of the Supreme Court. You follow it. The theory of the separation of powers is designed to forestall overaction, which necessarily results from undue concentration of powers and prevent despotism. Thereby, the rule of law narrows the range of governmental action and makes it subject control by certain legal devices. The reason why we have separation of powers is because we do not want power to be concentrated in any one person or any one branch of government. And when the president insists on interpreting the Constitution the way he sees fit, then it violates everything we are learning and suggests he has no understanding of the rule of law. Now, let's segue a bit. Why is he doing this? Oh, of course, I just said everything you're about to see. Yeah. Then, so when the president insists that the DAP is unconstitutional, he violates everything that we just learned. Literally every first-year law student knows. Diba? That's a very common phrase that you throw around. In this case, it couldn't be truer. In fact, that's the only thing you know. Well, hindi naman. But that's like a chunk of what every lawyer should know. And even if you're correct, you notice how the Supreme Court says, even if it was a question of policy, even if you were smarter than us, even if, it doesn't matter. We are infallible because we are the final court. Not because of, where does the Pope derive his infallibility? From God, diba? Oh, come on. It's an academic discussion. God can be subject. They're thinking separation of powers kasi mami. Right? Never mind if the court is wrong. At some point, litigation has to end. So, the president though, that's not the public. Those are his minions. But I couldn't find There wasn't enough time. Rather than in this part, rather than read from the text, there are like this is from the SWS, the social weather stations, and some of this is the most recent survey that they've conducted. And if we were to pit the executive branch against the Supreme Court, the executive branch is losing. The court, by standing its ground, has actually gained more support from the public. I hope. I mean, I hope I read the figures correctly. Net satisfaction rating in the Senate was moderate. Well, if you look at all of them, the Supreme Court is going up. That's really all it means. And they do this all the way from Tihanki. See? It's positive, positive, positive. Look at just to compare it with someone, look at the Corona period. Negative, zero. So it's significant. It's a significant change if you have a positive, integer on your side. On the other hand, you might say, well, the bar has been set so low. Hindi naman. Public satisfaction with the Supreme Court and Cabinet as a whole, plus 32, plus 18. I'm doing this because I think the president has decided I'm popular enough that I can. If anybody's going to stand up to the court, I'm going to be the one to do it. But that's not what the figures are showing. They're below. They're just pushing the Supreme Court up, which is good for the court because since the impeachment, they need a boost. They've needed a boost for the longest time. And thanks to the president, they're getting it. All right. The president's constitution. This is another illustration of what I think is going on. And this is what we mean when we say, whose ox is being gored? The court is a friend if you're winning. So if you're a liberal, you like the Supreme Court. This is the U.S. example. You like the Supreme Court because it declared unconstitutional the Defense of Marriage Act. Hi! Sorry. Long time no see. Court ends Defense of Marriage Act. But if you're a liberal, you also don't like the Supreme Court because court ends Voting Rights Act. It makes it difficult for minorities to vote. The same, of course, is true for the Republicans who don't like minorities because they vote against the Republicans and will not hate, they love this ruling, not that one because they're always officially against same-sex unions or marriages. Okay. And this is what I think is happening here. I think we can figure out what's going on if we look at the president's words a little more closely. A little more closely. I have a theory as to why the president is doing this. We go back to that Justice Summit where he first attacked the Chief Justice Corona at that time. And I think if we read the rest of his speech, which was not the one that's reported by the media, we can see his legal theory of governance. He's been trying to explain his point of view for the longest time. And these are excerpts from that speech. Am I reading from the same one? The power, this is a different excerpt on the paper. The power of the Supreme Court, the President, and Congress all emanate from the single boss, the people. Therefore, we should only favor and fight for the people's interests. I swore to preserve and defend the Constitution, execute its laws, do justice to every man and woman, we should really change that oath by now, and consecrate myself to the service of the nation. I have no intention of violating my sworn oath. I have no intention of failing the Filipino people. It is my obligation, it is everybody's obligation, to remain focused on a single direction, under one unifying aspiration, to serve and uphold the interests of the nation. To all those who stand shoulder to shoulder with us along this straight and righteous path, have faith. So long as we are on the side of what is right, we will not back down from any fight. And so long as the people are behind us, we will triumph. Let us not let them down. You got it? This guy has a theory of government that's different from the one in the Constitution. He thinks, I'm not saying he's wrong, huh? He has an understanding of what the president's job is, and that is to lead. And by leading, he wants everyone to fall in line and do the right thing for the Filipino people because that is our mandate. He's not crazy. Even if I make fun of him every single day. And then, let us look, for example, at the president's statement on Araulio, where he challenged the Supreme Court to a fight, diba? To the end. Oh, here's more from that one, from the Criminal Justice Summit. There are those who say that this decision might be a personal vendetta against me, etc. All I can say is, President, as the father of this country, is that we need temperance and forbearance. There it is again, that role of the father leading. It's parents patriae to the extreme. It is a version of that concept, that doctrine that I've not seen so sharply constructed by anyone. And if we look at his statement on Araulio, we see this. If we can just avoid the gauntlet throwing, the challenge to the Supreme Court, we find passages like this. Without doubt, any good leader would want to implement projects that benefit the public at the soonest possible time. I do not see any reason to delay benefits for our countrymen, especially because we have the wherewithal to alleviate their plight. We can do it. We have the means to do it. It is clear that if you delay the benefits due them, you prolong the suffering of the Filipino people. Thus, to the Supreme Court, our message: do not bar us from doing what we swore to do. Shouldn't you be siding with us in pushing for reform? Let us therefore end this vicious cycle that has taken our people hostage. And finally, let me impress upon everyone, that is good. Our intentions, our processes, and the results were correct. Bosses, I promise you, I will not allow your suffering to be prolonged, especially if we could do what we can as early as now. There, in those passages, I think is the explanation as to why this president doesn't seem to learn. It is because he already has a version of how government is supposed to work. And in his mind, he's right. It becomes evident, this is from me now, I can have an original thought, diba? The Supreme Court did more than, the President did more than criticize the Supreme Court for demonstrating partiality in its decisions. He was explaining his philosophy of governance. The President's fits are not a fit, like he throw a fit, not evidence of his childishness. The lengths he is willing to go to, impeachment, and even the amendment of the Constitution to curb judicial power, shows that he has a unique, if incorrect, view of the function of the President. So the President, to drive the point home, determines what is right for the people. All other branches who have the same boss must follow suit. And when the Supreme Court defies the President, the court is wrong. And if the court refuses to change its ways, then their power must be curbed. While there are three equal branches of government, the executive branch is more equal than others. Hence that title. I say this view is incorrect because the President cannot determine the will of the people on his own. And here's the problem. In fact, if you look at the recent opinion polls, he is kind of wrong. He's kind of wrong when he thinks that the next step, that first, that the problem is judicial overreach, and that the next step, therefore, has to be to curb the power of the judiciary. No one, or very few, agree with him on that one. The other important matter on this issue is that the President overlooks is that the people's will is already embodied in a document called the Constitution. We, the people, laid down rules in 1987 that are meant to endure over time. And some of these pertain to the national budget. And when the president violates the rules, we call on the courts, in accordance with those rules, to call him out. By focusing on other parts of the president's speeches, we arrive at an uncomfortable realization. The president's constitution is different from the one we are reading. The president's constitution embodies the separation of powers, but not a system of checks and balances. And his outbursts against the Supreme Court shows that his goal is different from a genuine it's not only concern for bias in favor of the Arroyo administration. The impeachment of the Corona no longer appears to be the culmination of a campaign to ensure judicial independence. The president is attempting to restore the balance of power under the Constitution with the president at the helm, and the Supreme Court polite and compliant at the wings. Now, our problem is we get distracted. We get distracted by the exciting stuff in his speeches. And look at the way the media reports it. War on the Supreme Court. Aquino versus the judiciary. Diba? So the public gets riled up. You know, we're polarized into separate camps because that becomes the issue. I'm not saying identifying or being able to identify the philosophy of the president makes things better. That's just the first step. Who is this? That's still part of it, right? Oh, this one, by the way, is from the his inaugural address. I went all the way back there to see, and that's the common theme is there again. All of us, side by side, we can do this. Side by side, that means stop disagreeing with me. Diba? Now, this morning, I triple-checked the internet, and I found a couple of people who agreed with me, although they say things in a slightly different way. And this is Patricia Evangelista. And this is, the reason in her mind, the reason why the president. Well, let's look at it. This is why the president simplified the narrative and dictate the terms of good and evil. This is a president who took office despite a lackluster Senate performance and a decided lack of presidential charm. That's harsh. It was enough that his father was martyred and his mother was offered as sacrifice. He was the child of the sun in the land of the morning, and the people crowned him king. It is perhaps because of this that Aquino responds to all criticism with an injured righteousness. He is a government that stands on the side of the angels. All who oppose him have sold souls to the devil. But I remember when I read this morning, I remember having this exact same conversation with the Solgen. When he said the problem with the Aquino administration is that when you criticize them, they get angry. They don't respond legally. What they say is, how dare you think we are capable of corruption? Instead of laying down a legal defense for the criticism. Righteous indignation. That's the phrase. I was thinking about that this morning. They are offended at the thought that you could think they are capable of wrong. And in Evangelista's point of view, checks and balances are not necessary because I am the president. It's okay. I am one of the good guys. That's why we seem to be dealing with a child. It appears like, because if you read the reactions over the net, they say things like, why can't you just admit you're wrong? He can't, because his worldview prevents him from admitting that he is ever wrong, or else nothing will make sense. That's the way he organizes the world and the function of government. And Dean Pangalangan also apparently said something along the same lines. We must rise above the din of partisan maneuvering and see that what rages today is not just a contest among political titans, but a clash between two competing bases of legitimacy. One is legal. That's what we throw at him. We call it the Constitution. We call it the rule of law. We say, hey, you cannot do that because the Constitution says you can't. His realm, in his universe, there's something superior to that, to all of these things that we call the law, and that's common sense and the public good. And when I say this is for the benefit of the public, You are not allowed to say otherwise. See? And what I think is happening here, that Dean Pangalanan still on that first paragraph there. The strongest challenge against President Aquino's insistence on what he calls the simple non-legalistic mind is that his daang matuwid, the right path, has itself relied on the power of legalism. And I agree. Those two worlds are not independent of each other. While we might have given him a lot of leeway, while we might have given him a mandate to go out and clean the ranks of government, we have anchored that mandate on the Constitution. And once he starts straying from what the Constitution says, we start to lose interest in him. That's why more of us now are allowed to hate him. Early on, he had more support because it looked like he was following what the Constitution was saying. Once he starts saying, "Oh, man, maybe I should have another term because my bosses want me to have another term. Maybe we should cut down on the Supreme Court's power because apparently it's too strong." Then we start stepping back and saying, "Wait a minute, that's not part of the plan." And that, I think, accounts for his drop in popularity. He's in a bind because he cannot, I don't see how he can change. It's like the old dogs, new tricks. Impossible. So what does this mean? By way of conclusion, calm down. What does this mean then for amending the Constitution? I think we have a problem. See, right now he's talking about cutting down judicial power and then extending his term. Although in the latter one, I think he started to backtrack on that one because he thinks that's the only problem we have with him. And this is what he said the first time that issue was raised. Look at that again. The Constitution, he does not feel the Constitution balances the three branches properly. He cited as an example Supreme Court, which he feels has too much power. I've started thinking about judicial reach. The Congress, the executive, go ahead and act, but at any time, the judiciary can castigate you. Aquino said it appears the judiciary is not practicing judicial restraint. So in his mind, the courts should, that's like the default system of courts, which sounds a lot like, let's see, the Marcos Supreme Court, right? I've heard that before. Let's see, martial law. When the courts would say, "Oh wait, no, let's not interfere in this one. It's a political question. It's a political question." I think I've said this. Right. By itself, an amendment to the Constitution is not wrong, but it has to be premised on the right things. If, for example, we had a study that says ownership of land by foreign corporations will benefit the country, then we should talk about amending the Constitution. We should have a study that analyzes all the safeguards we put in the Constitution, even judicial review. Why not? But the problem is when you launch this campaign and it's premised on the wrong things, like executive exceptionalism, then we're going to have this project is doomed. If the president says, we have to amend the Constitution because I cannot be the subject of judicial review, we have to amend the Constitution because I'm too pure. Kulang na lang sabihin niya I'm God sent, di ba? I mean, I can hear it. It's like the next thing, if he just keeps on talking, if nobody stops him, it'll reach that point. I am God's messenger. Get out of my way. And the president who arrogates unto himself, I think, the role of identifying what is best for the people sets out on a short road to authoritarianism. And the president thinks he's immune to judicial review. He consecrates that road. That is the only way this thing is going to end. This is not one of those, even the framers of the U.S. Constitution said, even if the Constitution is 2 centuries old, more than 2 centuries old, when they were writing it, some of them said, well, I think Jefferson said this, I'm not sure. I think every 18 years, we should review the Constitution. Nobody pretended like a Constitution really lasts forever. But the theory is that's the case. if we have a case for judicial for a constitutional amendment, by all means, let us have the discussion, let us have the debate, let us have studies upon which this debate can be grounded, not because you think one of the branches of government should be following you no matter what. Okay, and that's the way I think the Chief Justice gets it. I started with her because every time I read the news about her or listen to her, it's like listening to a constitutional law 1 class, which is what everybody has to hear. And in the end, she gets it right again when she says, I do not serve presidents. Actually, in the real quote, she says, excuse me. She said, I do not serve presidents, excuse me. That would be unforgivable. And the host, I said the host introduced her as the Chief Justice will probably serve 3 or more presidents. She said right away, I don't serve presidents. And they go, okay, how about endure? And she said, I don't have to endure them either. You know. So that's my feeling. The president is in a bind, and unless he learns that his way is not the legal one, that there is another tuwid na madaan, tuwid na madaan, daan na matuwid, and and that is the part you will all remember. that's that's the sad part. And unless he understands that, then when we are doomed. If he uses his popularity to amend the constitution for the wrong reasons, and in this particular case, we know exactly what he wants. It makes me nervous because I've been through it. I don't know about you guys because apparently I'm the oldest one here according to the evening class. That's it. So we're nowhere near your age. Okay, but we've been through it and it's not fun. And it's not fun. So when people start talking about cutting down on judicial review, extending the president's term limits, we get nervous. And and um, and that's where we are now. I think we have time for questions. Oh, it's his birthday today. It's his birthday. And I said, okay. No, 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 no. Jesus Christ. That's not the point. It's just a way to, lighten up the mood. We have time for questions. We have time for questions. Oh, good. Questions? As you can see, it starts out as a legal issue, but I'm afraid the solution isn't always legal. It's political. It's political because of the nature of this. The character of the president. So we may yet have a legal response in the sense that whatever he does, and he will always come across as childish to us because we know what the law is. Whatever he does, there will still be a legal remedy for it. A legal remedy for it. In other words, he's not going to get his way just because he is God's anointed. Questions? Yes, of course. That's her. The one who always asks questions. Yes, let's talk about the budget. Always back with that question. I said they can because the definition comes from the GAA. But are things uh, running as perfectly as they can? Then the answer is still no. Because when the president spoke to the FOCAP, he brought up Reyes, which is our example of how things are not working at present because Congress has decided to ignore a Supreme Court decision, a final Supreme Court ruling, and they've continued to allow Regina Reyes to sit in Congress. Then we have a president who starts talking about amending the Constitution because there is an imbalance of power. in these cases, I think that the constitutional system is under a lot of stress. Under a lot of stress. Is it working? It still is. It still is because the Supreme Court has, I think, I don't know if I'm biased because of the Chief Justice, because she taught me three subjects here. But I think when she says those things to the press, which are the things that you hear here every day, she gets it. And if we understand how the system works, that everything is going to run perfectly. When the president apparently he agrees with Congress on the Regina Reyes case, when the two other branches of government decide we can ignore the the Supreme Court, we are in for a treat in the sense that I don't know how this is going to end. Is it working so far? Are we bursting at the seams? Probably. Probably because these things are not supposed to happen. What I want to see is the president doing a George W. Bush, huffing and puffing and saying, "Ah, shucks, I have to do what the Constitution says." That's fine because that's exactly how the system is working. But where you have a Congress that continues to say the Supreme Court decision in Reyes is wrong and we are not following it, and then the president that keeps on saying the court in Araujo is wrong and they had better reverse their decision to be right, we are at that point when um, we're going to see how mature we are. Is it working? Yes, but I don't know how long. I don't know how long this is going to last because I haven't seen anything like this since martial law. Next, what's the next one? And then the next one. An audit? We asked the COA to do it. Yeah, we could do it. Sometimes the president appoints the members of the Commission on Audit, and sometimes they regret it because they do a great job. If the president truly doesn't want the truth to come out and there's a vacancy, they're going to start appointing compliant people. We had a time when we had a COA that just went out and audited everyone. Everybody got nervous. We got nervous. And not that we're hiding anything. It's just that, they might think we were hiding something. But that one is in the COA. It's an independent constitutional commission to an extent, diba? So if the right people are in the COA, that's fine. If the wrong people are there, sometimes you can go on for years and not hear anything from the COA. Next. We've been through this before. Inequality. Well, yes, that is unequal because apparently they have powers that are not stated. One, however, is that it's the Supreme Court's fault, right, in Manglapos for ruling that way. And two, I see the possibility of the court doing the same thing for themselves. But because when the Constitution gives us judicial power, they said all judicial power. And then I can see a future where they will interpret that and say, well, that means we can also do the following things, even if they're not specified in the Constitution. As it is, yes, I agree. There is an imbalance because I think Manglapos was wrongly decided. Is it the end of the world? Probably not. Probably not because they'll find a way to fix it. I think if the president starts quoting residual powers, and goes on a frenzy of executive what action, the court might say, "Oh, wait a minute, maybe it's time to Diba? Things, that's how the system is supposed to work. Eh. Things will balance out. Once they start seeing the president abuse that power, they'll say, wait, 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 not too much. Maybe we'll cut down on residual powers, etc. That will not be the end of the world. Thank you. She'll be back. Any other question? Any other question? Yes. Yes, Mike. Now they're asking questions on your behalf. To
make sure that the sorry to make sure that the president does not abuse further his
no, well, the ball is with the president. So the fact that in that last interview, the last in the FOCAP, he said, we are conducting a study on what to put in the constitutional amendment also worries me because apparently he has not learned his lesson. Insofar as seeking an extension of his term, he has backed out on that so far publicly. He's saying that's not a good idea. But he's still convinced that we need to amend the Constitution. So, until we see something concrete on his part, then we don't know what the Supreme Court can do. If the president has enough support in Congress, which means yes, he does have enough support in Congress, they might actually test the ambiguity in the Constitution and try to amend it, by having three-fourths vote of the entire membership of the Congress, and then the Supreme Court might decide, no, that's not the way we're going to interpret the Constitution. So it depends on how strong the court feels. And the court never challenges the other branches of government unless it is certain it has public support. If it is not enjoying public support, they will not even there. You will not even hear anything from them. Okay. Thank you. Now, the statistics that we show that's the kind of thing they love to read because it boosts their morale. They know they're doing the right thing. And in the end, though, everyone should be watching the polls. Our polls, I think, are solid, aren't they? And I think they should be worried about that. Today, in the news, they came up with a new poll that says Congress is the least trusted institution of government. I know that. Did you, did you have to did you have to take a poll for that one? But the point is that the court must be enjoying that sort of thing because they made a ruling on PDAF. They're not sure how the public is going to react, and then the public sided with them. Right? They made a ruling on that. Apparently, the public is still siding with them based on the latest survey of the SWS. So they're feeling good. Next. Yes. I think because of the way that's a good one. I think because of the way we wrote the Constitution, for me it's theoretically impossible for the court to overreach. Now, when I was just many years ago in this very auditorium, I heard legal experts say exactly that the court was overreaching whenever it exercised judicial review. At that time, the problem was uh, the the globalization and the economy. And as you will find out next semester, we put a lot of restraints on and to protect Philippine industries, etc., and stuff like that. And there were people who were agitating, trying to convince the public that the court was keeping us in the dark ages by blocking all the reforms of the Ramos administration. So, during that time, it was not uncommon for people to accuse the court of overreaching and saying they cannot have or shouldn't have a say on economic matters because they are not experts on economic matters. And that forum actually is one of in the Philippine Law Journal, one of those issues there. But I think, as I said, because of the way we wrote the Constitution, we gave it that power, remember? To look into everything. So that's when this kind of thing happens, that means their ox is being gored. That means they're not getting the way with the courts, and therefore the remedy is to vilify the courts. Remember that problem with the Panganiban? All of those problems with Justice Panganiban. His view is that when it comes to economic matters, we should defer to the executive branch. That's it's like he's trying to promote a canon of construction, a substantive canon, where if the issue is an economic one, and because the courts aren't experts on finance and economics, we should defer to the other branches of government. Now, the response of the Justice David at the time, and most of them, were saying that what we have to apply the restrictions on the Constitution. And all we're doing really is applying the provisions that we inserted in 1986. But if you're unhappy, then there's judicial overreaching. You understand? It's not a fact. It's a political perception. It's a perception on the performance of the court. Just as today, Arroyo is Aquino is the one who keeps on repeating that phrase, judicial overreach, because his ox is being gored. That ox called DAP. There will always be people who will say that. License? No more? Yes. I think I shall send the slides, but not this. Oh hell, I'll send you the lecture too. Because unlike previous years, there actually is one now. No, I'm kidding. But it's not yet finally, edited like for publication, but you can look at it. Yes.
Good afternoon, sir. I would just like to ask that is it because why President Aquino is doing this, running roughshod over the court, um, channeling public opinion towards his agenda to establish the notion that there's a judicial overreach? Is it because all of this is premised on the fact that our country is a poor country, and thus, for him, since he represents the poor, for him the law is removed from the poor, the law is an abstraction for them, and thus there's a need for this populist leader to unite the poor or to unite the public behind him, and so that the people will get behind him. And also, is it because our institutions are weak? It lacks institutional capacity, and thus we have a weak rule of law. All of this is because it is premised on the fact that our country is a poor one. Do you think so?
Okay, that's good too. On weak institutions, I agree. That's Joseph Migdal, for those of you who are political science majors. Like a lot of South American countries, interest groups run our government. And that is, I think, a product both of our poverty and our immaturity that we let this web of interests actually run government. That's true. I also think he likes to think he's a populist president. But I don't see him, um, I don't see him pointing to the poor the way you just did. I think, I think he thinks he's the president of the majority. And when he won, he thinks he was given the ability to determine what is best for us. In that sense, I agree. He sounds like a populist president. But is it because he identifies with the poor? I think not. I'm not convinced of that. But is he everyone's president? Yeah. Does he have to do what is best? Yes. He thinks he has no other choice but to do it. Now, is that a good thing? No, because we are far from the system of government that the Americans thought they were going to implant here. Diba?
Sir,
Yes.
just another
Yep.
question. Is the power of judicial review a duty that is immune to constitutional change, even to the revision of Article 8, Paragraph 1?
No, it's a duty because we have made it a duty. And if we, as a people, decide that we have written too much into the Constitution, we can amend it. If we wanted to abolish it, we can.
Okay.
But then we run the risk of having two branches of government running amok and doing whatever they think is right.
Thank you, sir.
Okay. Anything else? Yes. Are you ready with your next question? Because I just know we're going to segue back into the budget.
Good afternoon, sir.
Yes.
Sir, going through legal history, it seems to me that there's always a clash between the judiciary and the president. For example, sir, in the time of Roosevelt, there was a court packing plan
Yeah.
regarding the New Deal and many, many more. So, is it possible, sir, that this clashing between the executive and the judiciary is just an inherent problem with a tripartite system, wherein
Yeah.
and therefore, sir, it's really something that is unavoidable. And in relation to that, sir, another question would be to the professor: what would be a picture of a mature government that really functions in conformity with the Constitution?
Okay. On the first one, yes, it's inevitable. It's not when the branches of government are unhappy. That's not a sign that things are going south. That's a metaphor. It means things are deteriorating. Okay, and you're correct. That's exactly the way things are supposed to be. Remember that this system was what came about because we had a revolution, and by we I mean our American ancestry had a revolution that overthrew the king, as it were. And we decided we're going to break up government power so we don't have that kind of tyranny ever again. So it is built on tension because we put in checks and balances. You can't have checks and balances and not generate tension. It's like a referee in every game. The referee, if you're a Jaworski fan, is the enemy. And I know you're out there. Diba, you blame the referee every time you lose. The referee is always wrong because that's the referee's job, is to point it out. So, is it inevitable? It's not even inevitable. It is desired. It is desired. A mature political system is one that doesn't overreact every time we have that kind of conflict. We are supposed to say, "Yeah, never mind that picture with Bush. Bush wasn't supposed to huff off, run off in a huff and say, I hate the Supreme Court. In fact, if you really think about it, a mature political system is one that says, I accept the decision. Not even the huffing and puffing. Take that out. And if we understood this tripartite system that you described, that we already know, then no one is supposed to feel bad. Maybe disappointed, but not to the point of saying, oh, man, there's no balance of power. I have to change the rules. When your leader says that, I get nervous because to me that's like a sign of immaturity. Fewer things can lead to can signal that kind of immaturity. A statesman says the right thing, which is the Supreme Court has made a decision, and we will follow it, even if we disagree. Then I get if I hear that, my God, I can sleep at nights and not worry about the future of my children.
Second question, sir.
Yep.
Sir, it seems to me as well that the clash between the executive and the judiciary, barring corruption, etc., always has to do with the executive trying to push forward certain policies which are inherently against the Constitution. For example, Sir DAP, or in the case of Roosevelt, his New Deal, etc. Because the Constitution from the United States and even the Philippines is based on the theory that power has to be limited. Is that there? Is it safe to say, sir, therefore, that an executive trying to push forward economic progress really will be hampered always by the Constitution? It's just a reality. And in connection with that, sir, maybe that's where discussions would now have to matter regarding whether or not that worldview is still valid. If that's the worldview that brought about this Constitution, whether or not that worldview is still valid.
The, every government will be bound by the Constitution. And if your Constitution has an economic plan, as ours does, then we are bound by that as well. If at a certain point in time we agree that the constitutional approach is outdated, incorrect, even harmful, then we need to change it first before we can pursue other programs that are inconsistent with it. Or one other approach is for the courts to be liberal in its interpretation and to let the executive branch to interpret the Constitution so broadly, so liberally, that it will accommodate what might seem to be subversive approaches to economic growth because they're not in the Constitution. In the U.S., some people call that another way of amending the Constitution. They accept it, Supreme Court decisions can amend the Constitution, some sectors will say, by changing the interpretation that they've had before, which was very restrictive, to one that is more liberal, that allows change without actually going through the provisions on amendment and revision.
Because, sir, it seems to me that so long as the Constitution is there, inherently we would seem to be guilty of originalism in that we will always be bound by the economic principles of the framers. And those economic principles may now be obsolete. And sir, as you pointed out, it has to be amended, or either the Supreme Court has to be liberal about it.
But my view of the Constitution prevents me from departing. In other words, if the court decides, no, we cannot have an alternative view because the Constitution is clear, then I wouldn't fault them. I wouldn't fault them for saying that. But if reality is such that it looks like the world is falling apart, they can always do that and say, you remember Eastern Sea trading? They can say, well, that was our ruling 50 years ago. It's time to look at the issue anew. And they can do that with the Constitution and make it move forward without amending it.
Thank you, sir.
Thank you. Others? Yes. So you didn't wait to be acknowledged. Go ahead, De Castro. Oh, no. That's
Good afternoon, sir, and I hope you won't charge me for this question just like the CLU versus. Sir, if you are the Chief Presidential Legal Counsel of the President right now, how will you defend in favor of the DAP, sir?
the DAP.
Yes, sir.
I don't think I've ever been stumped before. The best defense that I've heard, actually, I'm quoting from them.
Yes, sir.
That the only thing we did wrong, I'm quoting, was that we might have used savings for another, by crossing boundaries in the Constitution. And then we think the definition of savings might be too restrictive and actually impractical. So, but on both points, remember, the Supreme Court said that's wrong. So, wait a minute, this is still related to your work, isn't it?
No, sir.
Okay.
No. Different office, sir. Different office.
But I think the reason why they changed the definition in the GAA now is to avoid the same legal questions the next time they are hauled to court. So what's their defense? DAP aside from what the president has said, which is good, we meant well, and it's done a lot of good. Even the Supreme Court says it's improved the economy. They will say that, and then they will say maybe we have to redefine savings so that we can have more flexibility in terms of budget management. That's like their way of saying, okay, we were wrong, but we can fix it.
Actually, sir, I asked that question because I'm coming from the perspective that if the Supreme Court, as they acknowledge that it's actually doing good, and if we acknowledge that desperate times calls for call for desperate measures, and given the fact that we acknowledge that the president's intentions are indeed clean, but the only thing that hampers is the way that he interpreted the Constitution. So that's why I asked that question, sir. If would,
Now I'm worried because can we actually, are you are suggesting that at some future case, the lawyers for the government might say the skies are falling and therefore we can interpret the Constitution in this way?
no, sir, no, sir.
Okay. But the default mode of any justice, any lawyer, because you will take an oath to defend the Constitution, is to abide by its restrictions. I do not foreclose the possibility that at some future point, let's say interstellar happens, but I'm talking a catastrophe of biblical proportions, that the court might be forced to re-examine its approach. But there is nothing so far, I've seen nothing so far that will justify so radical an approach to interpreting the Constitution.
Thank you, sir.
Now, Ms. Gosinia, yes.
Sir, this is with regard to the basic, Bangsamoro Basic Law. Do you think it's...
Why are you looking at me?
Wait, no. Do you think it's such a stretch of a theory, or perhaps a conspiracy to make, that the present administration's primary reason for championing the Bangsamoro Basic Law, or BBL, is to actually push for a change in the Constitution? And if it actually passes, then that's the way that they could introduce other changes. So in essence, to champion for ARMM
Oh,
or the
no.
Bangsamoro is just a secondary.
First of all, it's speculative, which means we don't have a case, an actual case or controversy.
Conspiracy.
Next, I imagine if the president's agenda was truly to amend the Constitution, they could have done it without coursing it through the Bangsamoro. And third, I've seen the work of the government panel, the Transition Commission, the draft Bangsamoro law, and my position is that there is no need to amend the Constitution for anything that they've introduced there. So if we're thinking conspiracy, I'm not going to side with you on that one.
Okay, sir. Thank you.
Anything else? Yes. Oh, there she is. And then, come on, go on. Go ahead. Go ahead, please ask.
Sir, what would be your comment on the perception that probably the reason why there is this president's constitution, his own view of governance is because of the cacique mentality, being a haciendero himself, and I think that's sir. Is there merit on that?
Yeah, that's possible. If we looked at if we by cacique we understand I understand it to mean in the traditional sense where they have a relationship with their workers and they rely on the workers. Probably. I do not know the extent to which he actually practiced being hacendero. I mean, it's different to be on the same clan and then own the property from afar.
Yes.
But did he actually walk the fields and then talk to the people? Because then your theory would have some basis. Diba? In the what is the theory that you're referring to? You're a political science major?
No, sir, journalism.
A journalist? Oh, that's why you're all here, aren't you? Pretending. In political science, Oh my, I wish I had reviewed this. There is a theory that explains the relationship between the ruling class and uh, and the rest. Does anybody know what that is? What? I can't hear you. Anyways, yes, what? Yes, thank you. Who's the progenitor of that concept? I think he's still alive. Very old. Patron-client relationship. Her question comes from the premise that the patron has a duty to take care of the clients. The clients do things because they expect to receive that kind of care and protection from the patron. So if he was actually a hands-on kind of hacendero, then that is possible. But again, we're speculating, di ba?
And then, sir, another question, sir. Since we are talking about some what appears to be some abstract, although very important issues, sir, I just want to bring this to a more concrete level. Like, sir, you mentioned earlier the role of the media in terms of the coverage, or sir, how would you, what would you say would be the ways so that the media could
Oh.
do a better packaging of the stories so that it will not be personality-oriented discussion only, but on the more issue-oriented.
Actually, I didn't mean to criticize them because I fell in the same
Yes, sir.
trap. Diba? I think our eyes naturally, or our attention naturally drawn to the more exciting
Yes.
parts of the speech. But let's say today, I think the ILS, or the Law Center, is briefing journalists on how to report on international law issues. I think we need that. I think we need that for all kinds of journalists, because this field is very technical. And and this one I've noticed, when they report on the Supreme Court, everybody just follows the press release because it's kind of technical. And since they don't want to miss, then they end up reporting the same thing, no matter what newspaper you read or click on, it's the same. But I want to see how that works out, and then maybe we can have, if we had a more mature media, we might be able to reduce tensions, among the branches of government.
Sir, last question, sir. How could the academe more concretely pressure the executive or the political departments to actually respect separation of powers?
This is starting to feel like a press con.
Sorry, sir.
But I think our job is this is part of our job. And because this will be, made public because we're in UP, then that our job is to educate the media, educate the public in general. We write stuff for all branches of government to consider. So if it's a question of policy, we have experts who submit reports and studies to Congress, and they work on those. That's our role. Sometimes to appear in media, sometimes.
But sir, how would you characterize the College of Law right now? Because in the past, well, in the recent, sorry, in the recent past, sir, the College of Law has been very proactive and has been very vocal about it, conducting press conferences, issuing statements, or on various matters, such as during Din Leonen and then Din Pangalangan's term, and then
I think we find ways to air our views, whether it's officially made or not.
yes, sir.
Sometimes it's just a question of logistics. You get bogged down by procedure, and instead of engaging in that kind of a debate, then just go and present your side, but no one is being censored or anything like that.
Thank you, sir.
You're welcome. Yes, from the Daily Inquirer. What?
Good afternoon.
Yes, hi. She's got a laptop. I should be worried.
Sir, no, sir.
How many questions do you have? Don't. Sige.
So, my classmates just wanted me to ask some questions. And I
Okay.
have some also. So they just collated it. Sir, we have 4 questions. Sir, the first one is, sir, she was
I think we're going to use that one on the website.
sir, sir, you've mentioned that the president and his administration are on their way to come up with amendments to the Constitution to lessen the power of the judiciary. What kinds of amendments do you think they'll come up with, and will those proposals and arguments stand?
I really don't know because they said it's balancing what we had during the martial law regime and what we have now, and then they keep on talking about the president keeps on talking about uh, judicial restraint. So I'm not sure. I'm not sure what they're thinking of, especially since the Athenians are advising him. No, 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 no. Don't read into that. I don't know how they think about these things. Diba? Most of their advisors are from Ateneo. I don't know what they're thinking.
Sir, second question. Don't you think in the siege on the courts, aren't parts of it rational, like the one on the JDF and Salen? Because in the past we've had Salen cases. An example is regarding the request for the copy of the 2008 Salen PDS CV justices of the ST and employees of the judiciary, where reporters and students alike filed for the disclosure of Salens and the personal data sheets of the Supreme Court justices, but they wouldn't release it. And until today, it's still hard for some of the media to get these kinds of information, even if the Supreme Court justices, like in a recent forum by former dean and now Justice Marvick Leonen, he said that our silence are available for everyone, but in reality, the processes to get those takes a very long time, and we actually need Supreme Court decisions for them to release for uh, an extended period of time. But here, they're just asking for the 2008, and it still took a Supreme Court decision. So, while I appreciate the characterization of a siege against the Supreme Court, sir, don't you think that some...
Did I put something about the Salen?
No, sir. I mean, it's an example because the JDF...
The JDF, the JDF, in truth, the Congress can repeal it if they wanted to, because it's a presidential decree. I'm just saying that they're doing it. It's a question of the context, the timing. If the president says you'd better not let the third branch of government step in, and then the following day they file a bill, to repeal the presidential decree creating it, then that makes me worried. Is it Sasalen? Is it valid? The reason why I didn't put it there because I also am confused about how easy it is, and they keep saying that all you have to do, they said, is just fill out a form and then we'll give it to you. And then Kim Henara says, well, that's not true. Diba? I can't get it. I don't get it. If they say the students were able to access it before, why don't you just pass it around? If someone got a copy of it, just pass it around. But is it valid? Can we pressure the court to reveal their silence? I think that's true. I think we can make a law that says even that makes available the silence of the justices. I remember the first time they said everybody's silence was open to the public except ours. This was way before you guys were in law school, and that even then was wrong, and even now it should be wrong. I think we should have a law that says their silence should be deposited, I don't know, with the executive branch. Oh, why not? Why not the BIR?
Sir, our next question is there a legal remedy to the supposed ideology of the president saying that he is the father of the state, etc.? Are we supposed to wait until he comes to his senses, or is there a legal remedy to make him see the light? Regarding
The legal remedy is every time we throw a case at him, that's it. That I don't see what else we can do. When he starts making shortcuts, even in the honest belief that this is the best thing for the Filipino people, our job as citizens is to file a case every time he violates the Constitution until he gets it. Until he gets it.
Okay, sir. Lastly, sir, Regarding the Arroyo Court, the Biraogo decision, um, isn't it uh, isn't it just like constitutionally, isn't it valid because of the equal protection clause? I mean, Aquino was attacking it because they were saying that it was
Arroyo
in
was
favor of
attacking. Biraogo was attacking it.
Biro Birogo was attacking it, saying that it was in favor of the Arroyo court, but the Arroyo administration. But constitutionally, is it really that flawed?
If we read the entire executive order, there were ways to make it apply to to everyone. But if the court refuses to see those and then just brands it simply as it focuses only on one administration. Actually, I don't think that's correct. I don't think you can invoke the equal protection doctrine to say it only focuses on one administration. Because I think if the administration wanted to focus on one, it can. It can justify it. So that's why I think it's wrong, and that's why it's up there on the list.
Okay. Thank you, sir.
Okay. Who's the other one? Yes?
Hi, sir. Good afternoon.
Hi.
From what I remember in our ICANN reading, breast milk formula, the court, the court admitted that they cannot rule upon certain issues, primarily because they may lack the specialization. So how do we reconcile it with the statement a while ago that, in theory, there is no such thing as judicial overreach? If the court held before that they cannot they cannot rule upon certain issues.
Okay. First, in the Mendoza article on breast milk, the court didn't say we cannot rule on certain policy issues. What the author was saying was that we don't want the courts to rule on policy issues because they are not equipped to deal with the issue. And I think, however, that that's the reason why we allow outsiders to come into the court to express their views. Now, in other countries, I think I said it in some of the classes. In the United States, when they ask for friends of the court to make an argument, they're not limited to legal groups, lawyers. And that is why various associations, any kind of field, they are allowed to make sociological arguments so the court can be enlightened on the entire picture, not just a legal one. Our problem here is every time someone appears before the Supreme Court, has to be a lawyer. It has to be a lawyer. And that doesn't solve the problem because we are not adding, we're not teaching the court anything. And just today, because I was looking for an article for this one, I found that article on what gay studies taught the Supreme Court, and that was relevant in our discussion of Bowers versus Hardwick because gay historians informed the court, told the court what was wrong with its previous decisions. And the Supreme Court said, oh man, how enlightening. We reverse Bowers. That's how it's supposed to work. It's impossible for everyone, for every justice to have a background on every discipline. What we should start doing is whenever we have a case that has policy implications, get doctors to testify. Get every kind of stakeholder to testify, to present evidence, not testify because we're not a trier of facts, to present before the court so they will understand. There's still no judicial overreach there. They can rule on breast milk. The legal method people are going, breast milk. They can rule on the issue of breast milk because they should hear what doctors have to say, what pediatricians have to say about it, how healthy, how is it, whether we should ban it altogether. Yes, you should know your doctor, Kepner.
Thank you, sir.
That's a little joke in the class. Doesn't you look like Kepner? Well, she did before law school got to her. Any more questions? Yes.
Sir, good afternoon po, sir. I have three questions. First,
is it possible for Aquino to start, or if he is, continue playing the legal game, given that in an article, sir, in the Inquirer early in this week, he cited two particular cases, namely the DAP case again, and
Reyes.
the case of Reyes versus Comelec, in claiming that the Supreme Court already has too much power to interfere with executive decision making. Is it possible, sir, for Aquino to start playing the legal game, or if he is,
Oh.
continue towards that path?
Well, I don't know. I don't know how if it's too late. I think the job of the people around him is to educate him on how the system works. The problem is, and we hear this all the time, it's all hearsay, but he doesn't want to listen to anyone. That's the problem. And there's a problem because if you're president, I think if I was the president and I heard about the Supreme Court's decision in Reyes, I would tell Congress, as a body, not as a superior constitutional organ, to say, what are you doing? As the head of the Liberal Party, I would say, the Supreme Court made a decision, follow it. Don't, but he's not doing that. And the fact that he raised Reyes for the first time, that's the first time he talked about it this week, makes me even more nervous because now I'm thinking Congress is getting its strength from the president's refusal to listen to the Supreme Court as well. That he should name that case next to that and say, see, that's what's wrong with the Supreme Court. That one makes me nervous. I think the president should start obeying the Constitution, and that he's not. We didn't elect him to be God's messenger, or worse, Galactus' messenger.
Yes, sir. The second question, actually, sir, second and third can be actually compressed into a two-part question. Sir, because in Araujo, sir, there was a substantial portion in the decision that told us that DAP was packaged as an economic stimulus package in light of the 2008 global financial crisis and as a means towards increasing economic development of the Philippines.
Yes.
Now, is it possible, sir, that it's a bit of a stretch considering that they used it as a defense in this particular case? And was it right for the court not to give much credence or credit to that particular argument?
Yes, because I don't think it's a legal one, even if it worked. The court doesn't have to deal with it because it doesn't go to the legal issues that were raised.
All right, sir. And this is the second part, sir. Given that Aquino packaged that as an economic stimulus, is it possible to see future versions of these economic stimulus being struck down by the Supreme Court?
I think Aquino packaged it as such because it's consistent with my theory about him being the only one true judge of what is right. Therefore, they don't have to make a legal argument. Where the thing is, this thing helps the Filipino people get what's wrong with you, Supreme Court. And if he doesn't change, he's going to keep on doing that one, and he's going to keep on losing. But I think the reason why Congress is amending the definition of savings is precisely to prevent another loss. And if the president doesn't see it, then his advisors are going to give him the legal scaffolding to survive the next round.
All right, sir.
All right.
Thank you, sir.
Any more? Anyone else? Yes, Kukweko. Yes. I think that's one strategy that they can employ. But the way they wrote the 87 Constitution, I think they were already thinking that. The president does have a lot of leeway. What the president is not allowed to do is cross boundaries. And the danger with answering your question is that, in reality, we can never know what legal issues will arise. And even if we want to be specific, we cannot. We will end up with a constitution that is so detailed, no one will go to law school. Because it's just not worth it. the effort to read all of it. Can we be more vague about it? Yes. Then that I think might be a way to cut down on judicial review, because they will say, well, it doesn't appear to be unconstitutional because there's a lot of room. So that's one way to do it. Like, oh yes, go ahead. I didn't mean to hurt your feelings. Yes. But the answer isn't Araulio, I keep telling you. The president was authorized to do it under what circumstances? What is that? When all hell is, when the stuff hits the fan. That's our. The president is authorized by the General Appropriations Act to impound, because I cannot remember the technical term. In essence, when stuff hits the fan. That is also actually in a way of answering your question. That is the reason why Aquino himself filed a bill before, right, to prevent impoundment. It also is, I think Senator Binay has a bill now. That indicates, one, that it's not unconstitutional. It's not. Number two, they could pass a law to do it, but then they could challenge the law and say there's nothing in the Constitution that prevents me from doing this. So that one's is an open question. Right now, they can. Right now, Congress allows them to do it. Right now, it's not unconstitutional. It's not. Because I haven't answered her questions in her email. She's raising the questions now. Ang haba kasi eh. Any other questions?
Sir, during the heat in the discussions between the President and the Supreme Court on DAP, there were people who were peddling the fear that the Supreme Court might retaliate through its decisions. Were those fears grounded? Do you think those fears were grounded? Retaliate against the President through its decision.
Wait, for what?
For attacking the Supreme Court so publicly.
The court, you know, the Chief Justice is correct when she's just like toning things down, saying, I cannot comment because there is a pending case. All my answers have to be measured. You know that. That's what she says. That's what you should say when you're the Chief Justice. Also because, in the end, if you set out to fight the executive branch, you will lose. They will not do it. They will not retaliate because they will lose. Because they will lose the budget. Because they will lose the JBF, etc., and their retirement benefits, etc. So they will follow. As long as, however, see, this is what they're banking on. If they know they're right, if the people are behind them, they can make bolder decisions. And I say sometimes constitutionally correct ones, like PDAF and the DAP cases. When they are intimidated, they're not even going near. I think that's what that's why they upheld PDAF before. Because they are not in any position to challenge another branch of government. Then when the police comes along and they feel this pressure, somebody has to pay for what's happening here, then they step up. And they were right. All of a sudden, it's unconstitutional. Same principles, same acts. Now it's unconstitutional. That's the politics behind this. Will they retaliate because the president is scaring them? No, they won't.
Okay, thank you.
Anyone else? What was that hush when you stood up? It's like a. Anyone else? The only reason why I don't call you right away in class is because you keep moving seats. So I go, any questions? And I'm looking, where is she? And sometimes, sir, she'll be late. She's coming in, and that's why. That's why nobody's asking questions yet. Anyone else? more? All right, that's fine. Okay, the deadline for your thoughts, Thursday noon, okay, with the OCS. Remind me someone, please, to email both the slides and the lecture, so you can look at it, and you will have no excuse whatsoever about me. But be patient with this, because I did it this morning. No, I didn't do it this morning. I did it 2 weeks ago. But I still have to have people check it, diba? Anything else, Anna? Then thank you very much. I really had fun today. Thank you. I think I was supposed to answer the questions here. Now this makes more sense. Oh no, my cheating squad. Too late. You may go. Go study something.